Thank you, my lord. My lord, I'll make 5 highlights. My lord, I make 5 highlights, relying for the rest of the argument on my written submissions. I'll highlight the issue of regressive taxes, the statutory instruments question. I'll take you through the public participation issue, my lord. And lastly, the climate change violations. My lord, and then I'll conclude with the issue of money bills and money bills concerning counties. My lord, beginning with the issue of regressive taxes, Article 10, 21(3), 201 demand that taxation must be fair. In the Charles Macharia case delivered last week by the Supreme Court, the court restated the Article 21(3) obligation of all state organs to redress the needs of the vulnerable. In that case, children in juvenile justice, in this case, the poor in taxation. My lord, the World Bank, in its June 2023 economic update for Kenya, indicates that Kenya has been beset by an economic polycrisis because of the worst drought in 40 years, because of the lingering effects of COVID-19, and because of the ongoing global economic meltdown. The National Treasury acknowledges that. If you look at page 94 of the 2023 BPS, the National Treasury tells us that for the first time in 5 years, the rate of inflation is above the government target. First time in 5 years. And what is the impact of that? It pushes millions into severe food insecurity, my lord. And that set of circumstances has a legal effect. It invokes Article 10, social justice, protection of the marginalized. It engages Article 21(3), measures to protect the vulnerable. It invokes Article 201, equitable and fair tax measures. Lord Adam Smith and Atia Waris, whom we've cited in our bundle of authorities, explain that fairness, the word used in Article 201, demands that one must pay in proportion to their income. And so, my lord, Mr. Sore, my friend, will tell you that this is theoretical, but there's something called a regressive tax. A regressive tax is not fair because it pushes the burden to some people more than others. It affects the poor disproportionately. My lord, in 2018, the National Treasury confirmed that doubling VAT on petrol violates the rights of others because it increases hardship, it reduces disposable income. And the other thing that BPS tells you, my lord, is that the poor spend more than 60% of their income on food. Ordinary households spend about 54%. It is in the BPS. And so, when in an economic polycrisis, where government is saying that there's a runaway inflation, life has become hard, then you double VAT on the cost of petroleum. You impose excise duty on fish. You target milk specially formulated for infants. You impose excise duty, my lord, on powdered juice, foodstuff. Then that is a regressive tax. My lord, it's reminiscent of 1 Kings 12:12, where the people tell King Rehoboam that we are suffering, can you lift our burden a little? But he says, I'll double it. That is what happened here. I turn next, my Lord, to the argument that the National Assembly makes. It says that these are policy issues. Do not go into them, so that you do not interrogate the fairness of the taxes imposed by the Finance Act 2023. The same argument was made in William Musembi. Policy is mentioned 23 times in that judgment, in that case, which I argued. Same issue, dressed as political question doctrine, is made in the CDF case, again, which I argued. The Supreme Court had the CDF case. My Lord, the Finance Act, even if you could not determine issues of policy, the Finance Act is an act. It is not a policy. What you cannot do is decide which policy option the state should make. But once the state makes a policy decision, then it's justiciable. Under Article 10, anyone who formulates a policy or implements a policy, or under Article 165.3, anything done or said to be done under the Constitution. And so, my Lord, that should get rid of that argument. I turn to the climate change issue, my Lord. Now, they increase excise duty on glass bottles and on paper packaging. What is the impact? The impact on increasing excise duty on paper packaging, imported paper packaging, is to pile pressure on our forests, is to make people to resort to unclean options like plastics. That violates or threatens Article 42. And it is irrational, my Lord, considering the Climate Change Act 2016, and that this year Kenya has hosted one international conference on climate change and will, in November, host another on reducing plastic pollution. Yet, this is the year that the National Assembly chooses to impose excise duty on glass bottles, on paper packaging, and to increase VAT on natural gas, a clean energy option. Please find that those climate-leaning amendments violate the right to clean and healthy environment. My Lord, permit me to turn briefly to the money bill question. Now, if you look at Article 109, the entirety, a bill can be introduced in any house. But under 109.5, a money bill may be, the word is introduced only in the National Assembly. The National Assembly, the Attorney General, KRA, take the word introduced and magically transform it to debate. They say that a money bill can only be debated in the National Assembly. My Lord, that would violate Article 96 because, and the Constitution cannot subvert itself. So you must harmonize 96, harmonize 109.5, and harmonize another article, that is Article 114. Article 114.2 explains why the Constitution demands that a money bill may only be introduced in the National Assembly. And that is because under Article 114.2, National Assembly is given an initial filtering role. One of the few, if not only, situations where the Constitution directly imposes a duty on any committee of Parliament. You will not find it anywhere. Under Article 114.2, the National Assembly must proceed only in accordance with the recommendation of the relevant committee of the Assembly after considering the views of the Cabinet Secretary responsible for finance. That is why 109.5 says you can only introduce a money bill in the National Assembly in accordance with 114. 114.2 says when a money bill comes in, you can only proceed after considering the views of the committee one, and the committee itself after taking into account the views of the CS for Treasury. My Lord, that reading is constitutionally compliant. It honors the obligation of the Senate to protect counties. It honors the role of the National Assembly to play that initial filtering role, and it respects the value of bicameralism. My Lord, what can affect counties more than their revenue? If, my Lord, this is an argument accepted by the Supreme Court. In the CDF case, the Supreme Court was told that look at the objects of this amendment bill. It has nothing to do with counties. It does not mention counties. But the Supreme Court found that the CDF Amendment Act, not the entire act, my Lord, the Amendment Act, was a matter concerning county governments because it impacted county revenue. My Lord, under Article 102, revenue raised nationally is shared equally among national county governments. So the more the Finance Act raises, the more counties have to share with the national government. The less it raises, the less they have. The Finance Act is a matter concerning county government. And my Lord, it's not just about that revenue. The other things they put in there, housing, statutory instruments, including those made by counties. And my Lord, I turn next to the statutory instruments issue, repeal, the Statutory Instruments Act, whose Section 21 is repealed by Section 88 of the Finance Act. First, it is not a money bill issue. It shouldn't have been in the Finance Act. My Lord, if you look at the list of the statutory instruments, page 56 of our amended petition, you'll find there the Witchcraft Act, Cap 67. What does the Witchcraft Act have to do with finances? Mr. Sore will tell you that because of 114, these are incidental matters. They can go into a money bill. But the Witchcraft Act, my Lord, how is it incidental?
Probably the chief will have just one.
Yes, my Lord. My Lord, the Subordinate Courts Separation and Maintenance Act, my Lord, I beg my colleagues to just allow me 3 minutes to finalize. The Subordinate Courts Separation and Maintenance Act, Cap 153. What does that have to do with taxes, with levies? It is not a money bill issue. The Telegraphic Press Messages Act, Cap 512, which you find at page 62 of our amended petition. My Lord, I wonder when the last time my Lord heard of a telegraphic message. In short, they put non-money bill issues into the money bill, the Finance Act, and this is why they did that. In May this year, Annexure CN 1, 2, and 3, you'll find a resolution and answer debates by the Senate refusing to extend the life of some 1,700 statutory instruments whose term had expired under Section 21 of the Statutory Instruments Act. My Lord, that staged automatic expiry has a constitutional value. If you look at Article 96(4) of the Constitution, delegated legislative power is limited. It's limited because Parliament itself is exercising a delegated power. And so when it gives it to the Cabinet Secretary, it must retain some control. And so the power to make delegated legislation is controlled. Section 4 of that Act, the Statutory Instruments Act, requires mechanisms, my Lord, to ensure the ongoing review of statutory instruments to ensure their continued relevance. Regulations made under the Witchcraft Act, my Lord, still bind the Kenyan people. You'll find regulations made under repealed acts. The law is that if you repeal a statute, the regulations continue unless separately repealed. And so, my Lord, the purpose of Section 21 was to ensure the ongoing usefulness of statutory instruments. The National Assembly knows this. Look at CN5, which is the report of the National Assembly, at page 552, it's the National Assembly, I quote, notes the importance of constantly reviewing the statute book. The Senate also knows that. You'll find that at CN Roman numeral 1 at page 51 of our amended petition. The Senate says it's important to scrutinize the statutory instruments to ensure their relevance, justification, and rationale to extend their life. And my Lord, they can only extend for 1 year, 12 months. And so the purpose and effect of repealing section 21, my Lord, was to defeat that Senate resolution. And you'll hear the Senate Speaker telling you that they had agreed with the National Assembly Speaker that this bill did not concern the Senate, despite this amendment. And so, my Lord, find that one unconstitutional. Look at the Queensland Statutory Instruments Act 1992. It explains also the rationale for staged expiry in a manner that concurs with what the National Assembly and the Senate say. My Lord, allow me to conclude with the issue of meaningful public participation. My Lord, you decided the CIC case. Justice Odunga decides Robert Gakuro. There are other decisions. And my Lord, we are not saying that every view presented must be adopted. No, that is not the claim here. We are saying that every view presented must be considered. That is the law. My Lord, that is the law in BAT Supreme Court. That is the law in the GIFT principles, the global initiative for financial transparency, which Kenya has signed up to. It's also the law in the OECD principles, clarity of subject matter, my Lord, complementarity. The view presented must be must be considered, and the state organ must demonstrate how they took into account that view or why they rejected it. My Lord, look at page 398 and 399 of CN5. You'll find this remark. The committee rejected the proposal by LSK, full stop. Rejected why? Was there a better view? Was LSK disliked? Rejected why? My Lord, page 467, Okoa Uchumi, the people I represent, the committee rejected the proposal, full stop. Rejected why? What is the reason for rejecting? Trade Union Congress is a petitioner here. Page 469, the committee rejected the proposal, full stop. My Lord, the report does not show that every submission given was considered. My Lord, there's worse. The KRA at paragraph 44 tells you, 44, that the National Assembly considered all views given, but 44 times, CNX 5, the CFA and Twaweza counted and found 44 submissions left blank, without a reasoning, without indication of what happened to that, 44 times. And my Lord, about 80 submissions cannot be accounted for. What happened to them is not known. And so, my Lord, we submit that there was no meaningful opportunity for balanced influence on the decision. The last one, Okoa Uchumi, page 316 to 361, makes 57 submissions, nearly 60. Only 4 are recorded. Of those 4, 2 are marked as the committee rejected the submissions. My Lord, there was no meaningful influence, meaningful opportunity for public influence. Thank you so much, and I apologize to my colleagues for exceeding the time.
Mr. Odam.